Okay, thank you, Ziv, and thanks for all of our very interesting speakers. So I'll just grab away. So we open the floor for questions, and please, if you may, or if I may, just present yourself if once you are asking your questions or raising your hand. So please. Opa. Someone want to start? Okay. Yes, Anat.
Hi, I'm Anat Stern. I'm from two places. I'm from Tel Aviv University, and I also teach at
According to answering to your question, we took over the isolation institutions later in the western part of our country. So it was naturally we didn't have a possibility to enact any provisions to the institutions that were not under Polish control, and these institutions in the former Russian territories were we have taken over them in the first place. So these first provisions were devoted to these institutions.
I have more questions.
Smadar, please.
Hi, I'm Smadar Benatan. I'm a PhD student here at Tel Aviv University. I have two questions for Ziv and for Ronnie. Ziv, the military tribunals you were talking about, first of all, were all of them international in nature or domestic, like belonging to a court-martial system or something like that? And were they used primarily to judge soldiers of the same power, or enemy combatants, or both?
Okay.
Laws of war.
I'll try without the microphone.
No, need it for the filming, yeah.
For history. So regarding which kind of tribunals were they, so it's a complicated, the answer is a bit complicated. Until the mid-19th century, and it varies between countries, the military system was not part of the domestic criminal law system. It was a distinct legal system that its basis of authority was the prerogative of the commander to discipline his own soldier and enforce the law of war, and it's a prerogative that originated from the law of war. So it's a different system, and it enforced both kind of norms, both what we would call today military law and law of war, and it punished both soldiers of their own compatriot soldier and enemy soldiers. This is the common way in which war criminals were punished, by what we call domestic, and I call monopartisan because it's distinct from the domestic system, and that's until the 19th century. The exception, but it was not that rare, was the creation of an international or a multi-partisan tribunal to punish war crimes, but it existed. Again, certain examples from the 19th century and many examples from earlier. So that's for the first question. The second question, remind me?
I think you already answered it. Was it only for enemy combatants?
So it was for both, and generally based on unwritten. When it was war crimes, it was for unwritten norms. When you had another layer of the articles of war that were used to enforce to punish compatriot soldiers.
Could you please elaborate? And when you say international, you mean people from
there are many examples. So I'll give you, for example, you have many tribunals, the Scottish and the British, and the English, sorry. The Scottish and the English fought a lot during late Middle Ages and early modern time. And for several hundred years, they had a system called the truth tribunals or the truth day tribunals that punished, among other things, violation of the truth when there was one. And violation of the truth was considered an international crime. You had tribunals of several countries. You saw von Hagenbach, but for example, in the Boxers' War, you have 4 countries. So it depends and it varies in different situations. It's very rare that it's the belligerents from both sides, except in a situation in which there's a truce. In other situations, it's usually your allies punishing enemy soldiers or both enemy soldiers and your own soldiers.
You described the transition from an analytic system to a more hermeneutic interpretive system, and I was interested to know whether you link it to the development of natural sciences at the same time. It seemed to me like maybe the legal profession was somehow disqualified as a science and then seen more as related to humanity or moral, like talking about moral certainty or...
Well, it's very difficult in the sense that I see I see a very strong interest of jurists, especially in the 17th and 18th century. Most jurists are also interested in moral sciences. They also have to follow in the university the courses of philosophy and different. It wasn't only legal subjects that they had to follow, but they took this notion of moral certainty directly from people like from philosophers like Locke. Now, what happened in the 19th century is, that's sort of what I'm now still researching, where the notions of jurists came from. But what I see so far is that the legal profession, and this happened most strikingly in Germany, the universities, the faculties got more specialized, and the jurists got more specialized as well. In the late 18th century, the debate on cumulative evidence was a very open debate. And the empirical turn and the sort of new ideas of the natural sciences had their influence then. But in the 19th century, in the first half, the debate became a lot more specialized by jurists and only. If the jurists had the idea that they were sort of disqualified as a science and that they had to then only for that reason use a hermeneutical approach, I'm not completely sure if they articulated it in that way, jurists themselves. But I do think it was a factor. At least they did start to see what they were trying to find in a criminal case in a different light, as no longer forming, for example, the certainty that physicists are looking for, but as something, a truth that on which you can act in normal human life, in daily life, for a different certainty. So I think, subconsciously at least, it had a very strong impact. But yeah, I hope I answered your question.
Can I comment? You should look at writing that deals with the way in which culpability is proven. And there's a transition in that time from notions of manifest criminality to notions of a belief in the ability to recognize the sorrow of the person. So there's a change in the understanding of mens rea. So Fletcher wrote about it. There's a nice master of Shai Lavie's master in Hebrew. It's excellent about it, and what he shows there is that it correlates with the development of modern social sciences that leads to that transition, and I think that's it related to your research.
Can I say one very... well, it's very interesting that you say that, and I have to talk with you about it a little bit later, but I have also found one author that really says, because mens rea became more central, because it actually had to be proven now that somebody had a certain intent, that's something that cannot be seen on the outside by witnesses, so different forms of evidence, conjecture was allowed now. The judge could try to find his intent. Yes, but that did have an effect, I think, in the course of the 19th century, but it was not the great initiator of the change, because mens rea the importance of needing to prove it only started after the codifications and in the course of the 19th century. But for example, the French already introduced the jury system before that, and put the intime conviction central. And the difficult thing is they did not motivate that decision by, for example, saying that mens rea can only be established in that way, by changing the criminal law of evidence. So I have not found links in that, in at least the motivation why the reforms were made. So, but it is a very important factor.
So just was a bit ahead and then okay. Please.
Describing the transition from public punishments to labor, it sounded like most of the reasons that you were describing, at least from people of the time, were more kind of pragmatic, that public punishment just isn't working, it's not really creating any change in these criminals, and it's even worsening the situation. I'm wondering if there was also a kind of more moral discourse about the problematic aspect of using humiliation as a punishment, and how that, correlates or doesn't correlate to ideas of human dignity, and that was at all part of the discourse, which today we would obviously expect, but maybe then was not existing.
Thank you. Where your question, I think, raises a good, because much of the evidence that I quoted from the newspapers that were describing these men who were laboring in public was pragmatic, where there was pragmatic. There were also writers who say these men are not laboring hard enough. Here's other chores we could have for them. But the gentleman who I mentioned at the end, Benjamin Rush, in his lecture that he delivers at the house of Ben Franklin in 1787, he makes the argument not that this is degrading particularly for the men who are these public spectacles, but it's degrading to citizens who are observing these men, and then they wish to sympathize with the men's plight and relieve their distress, but they can't because the law prevents them from acting on their sympathy. So what Rush is really, really concerned about is he's afraid that these spectacles of public labor will create what he calls abortive sympathy, which will then the citizen, the spectator, will feel it. But since he or she cannot act on it, he or she might lose the ability to have sympathy in the future. And Rush theorizes that it's bonds of sympathy that will unite people in a republic. So one thing he says is if you remove these people, the criminals, from public, then citizens will only imagine what happens to them, and they will not truly know their pain or suffering. And so he thinks then they won't want to act on these sympathetic impulses. But then at the same time, he becomes a member of a group of prison reformers called the Philadelphia Society for Alleviating the Miseries of Public Prisons. And so they go into the prisons to try to relieve the distress of the prisoners and try to promote their dignity. But then Rush also makes the argument in the lecture that one of the things that he finds bad about public labor is that since criminals are subjected to this shame or scorn, that they'll have a lasting mark of criminality on them. So he imagines if they're taken to a place that's hidden from public view, when they return, they'll be like a prodigal son, and people, their family members, will miss them so much and wash them in tears, but yet nobody else in the community will recall why this person had left. So then that person could truly be reformed. So pretty much what Rush is making the argument is if you remove the criminal from the site, the public site, and place the criminal somewhere hidden, but still keep that labor aspect, then it will work. But unfortunately, he miscalculates his actual objects of reform and doesn't see them as people. Thank you.
basically working on the Netherlands. And so I was wondering if part of your research was also the different transfer movements that might have taken place, the networks among lawyers. It was part of your research because that would be something that I'm particularly interested in. If you could say something about it.
Well, I'm studying the Netherlands in the sense that it's the more or less undiscovered, uncharted territory. But I'm also doing a chapter about England, Germany, and France. And especially, well, what I see for Dutch jurists is until around 1800, the Dutch jurists looked intently at what French writers were saying on the criminal law in general, what needed to be reformed, and they followed those ideas quite uncreatively. And after about 1800, the Dutch turned their gaze towards Germany and started to look very intently to everything that was being said in Germany about criminal law. And then they followed everything they said. But sort of links, I think that really starts only later in the 19th century when you have like international or criminal organizations on the criminal social sciences and stuff like that. But that's not happening so strongly yet in the late 18th century, I have the idea. I have not seen very strong transfers of jurists working together, actually. I think that has a lot to do with the subject. You see it a lot more in the natural sciences and in different fields. That exchange is there, but the Dutch are often writing on, criminal law in the Netherlands, how it's being applied there. Only a few authors become renowned internationally. So it's not a big factor in my research.
Stephen Bogle from University of Glasgow. I'm a tourist in this session because I'm a private lawyer. I was going to say to you, Ronnie, just out of interest, Scotland has only just decided to abolish its law on corroboration. So and actually still presently, you still need two independent pieces of evidence to corroborate crime in Scots law, like from sexual offences through to theft and all of these different crimes. I'm a tourist in criminal law, but it's very interesting that it's that idea of two independent pieces of evidence maintained in Scots law right up until Parliament last year changed it, and now we're trying to reconstruct our system of evidence to deal with the abstraction of that. But also, there's lots of Scots lawyers went to Holland in the 18th century, so you could look at what they were getting. Mostly we took a lot from Holland, actually, more than we gave to you.
What you say is not so peculiar in the sense that, like I said, it was often a transitional phase where it became a negative system, where you still had to have certain minimum requirements. For example, in the Netherlands, still we have the unus testis rule that you have to have at least one witness. But the thing is, these rules have been marginalized further and further, and the internal conviction of the judge has become central. And my point is also mostly that this change, and also in discourse and how it was approached, that is central. But often there are still certain rules. Only the French very outrightly stated the jury was completely free and abolished it. And also Germany eventually did a similar thing. But in Germany a similar thing happened. But yeah, vestiges of the old rules still often remained. But this is a peculiar one, the corroboration rule.
Another one? Okay,
Yeah.
so.
One more. I don't know how many in the room are historians by trade, but I wanted to ask Jonathan and Christophe about Foucault, and maybe you can tell us a little bit if you considered the theoretical framework when you talk about incarceration and relationship with power.
If I can stay. I read the book of Foucault, Discipline and the Punishment, and I can say that in former ages punishment was a form of the power, but when I look at the discipline and punishment nowadays, and when I take, for instance, Polish prison system as the point of reference, I cannot perceive this prison system as the part of the power, which is interpreted in the way proposed in the book of Foucault. I think that it is due to the functions which are connected with the power in the Foucault's vision, and prison system, precisely Polish prison system.
Thank you. It's funny where Foucault, he haunts all of my work. For, say, an example with this essay, where Foucault talks about trying to get this discourse down about criminality and to establish a story of the criminal, in a way, that power hopes to establish. And what I thought, there's one, it's a sort of a nice suggestion from that Lippincotts magazine that talks about an alternative story, where this is the story of the wheelbarrow men being told by servants to the children who they're watching over. So you can see that they might be trying to mobilize this discourse in one way, while in the lecture that I quoted from Benjamin Rush, what he wants to do is establish the discourse in the way that Foucault had hoped, well, not had hoped, but what he was describing, because what Rush was hoping was that this prison being a place of secrecy, that nobody would know what would be occurring inside of it, and he even imagines that it will be placed in a valley, and when the door would open and close, it would creak, and that creak would be echoed off the mountains in the valley. Likewise, the clang of the prisoners inside, while they're laboring, that would echo. But since nobody would know what was going on, they would only hear it. And so what Rush imagined was that parents would tell the stories of what happens in this prison to their children to compel them to be obedient. So you can see how that's playing on. But yes, where Foucault is probably all over my work, and so I will stop here. But thank you.
Sorry, if I can say one small thing about Foucault as well. For me, he's also been, a large inspiration because of his innovative approach. But he also has a lot to say about the criminal law of evidence in Discipline and Punish. And I have to say that is, it's full of errors, but it's just in general, it's completely inaccurate. It's really, really bad in a certain way. But, yeah.
You mean the judicial torture or these kinds of
Yeah, I haven't. Strangely enough, I haven't said anything. Yeah, strangely.
the kind of judicial confession and torture?
Strangely enough, I didn't say anything about judicial torture, but judicial torture was used to obtain a confession because often two witnesses, of course, were not present, and Foucault gives that a very central place in the system, in the criminal system of legal proofs. But it actually was a relatively marginal element in the sense that it was used only very sparsely, and he presents it like it was the normal course of events, that there was this interaction between the executioner and the suspect. But it actually occurred very infrequently, and a lot of other aspects about what he describes as the big transition is just, is, I wouldn't say untrue, but it's very unlikely. But the sort of link between different forms of punishment and the criminal law of evidence and sort of the whole development of a modern system of criminal law, that is certainly, there I think he was very much on the mark there, that there's an interaction also between different punishments and the criminal law of evidence. I'll stop here, I'll just... Okay.
Thanks a lot. So I do have another question for you, but as a member of the organizing committee, I will pay attention to the time, and then, so I want to thank to our 4 speakers that these were very interesting discussions and lectures, so thanks a lot. And I'm sure that each and every one, if we have another question, so we can continue during cocktail. We are leaving, when the guys that are here, we are leaving at 4:30, so please try and be around 4:20 on the eastern steps, just outside of faculty. We're going to take the bus to downtown, to Kikar Bialik, to Bialik Street, and then we have our cocktails, and then the other part of the conference, or the first day. So thanks a lot again, and I do hope you're going to have a nice time ahead of us. Bye-bye.